Hi, I'm David Zimmaro, the owner of Zimmaro Law. I've been helping clients with personal injury related matters for over 25 years. I've put together the following video to help provide some insight into commonly asked legal questions. While this video serves to provide some general information around the practice of areas discussed, it should not be taken as legal advice, and you should always consult directly with an attorney to make sure the specifics of your particular situation match up with the various laws within those areas. The choice of an attorney is an important decision and should be given careful thought before deciding. If you need representation or have any questions, don't hesitate to contact me at 724-222-1221 or visit my firm website at zimmerolaw.com. That's zimmerolaw.com.
Hello, good morning. I am joined today with David Zimmaro, the owner of Zimmaro Law, who is a personal injury attorney located in Washington and the Pittsburgh area. You've been practicing law for over 25 years, that's right?
That is correct.
So today we're going to talk a bit about the personal injury process. So basically just the steps and stages that go into when, someone initially comes to you and how, what they should expect as they're going through their personal injury, case. So just to kind of start question, first and foremost, what is, the basic outline, a guide that you could provide for someone from start to finish going through the personal injury case. So we're going to start with, they initially call you up saying, "Hey, I've been in an auto accident or I've been injured in some way." And I assume we're ending with, a settlement of some sort. So what are the steps that we can expect in that process after someone calls you initially?
Thanks, Nick, and good morning. So that process does vary pretty significantly depending on the type of case. I guess I would say all cases start the same way. A potential client, reaches out to me. We have a conversation on the phone. Um, if I think there's a potential lawsuit, potential cause of action, then we'll set up a meeting and we'll go through things a little more in more detail. From that point, the cases they do vary depending on the case. So you have your cases, let's say a automobile accident, motor vehicle accident case that where there's clear liability, okay? And you have moderate to relatively minor injuries. So, as far as the time frame, I mean, it's possible. It's possible to have a resolution in that type of case in, say, 6 months. Um, the important thing with that type of case, though, or a similar case, is we, you, the client, your lawyer, we need to be sure that you are at maximum medical improvement before we can really even value the case. You don't want to resolve a matter prematurely and find out down the road that you had injuries that weren't factored into the valuation and the settlement. That things that your long term prognosis was worse than expected. I mean, there are scenarios where you may not know that with 100% certainty, but you just want to, we need to be very careful to make sure we have an understanding of all of the injuries and what the likely outcome of those injuries are going to be. And then we can place a value on that case. And then once we can do that, if it's an automobile accident, a clear liability matter, most likely the defendant, the negligent driver's insurance company will want to entertain a settlement discussion. And if we can come to a meeting of the minds on the value and a resolution, it's possible, we can resolve that case in 6 months or so, a little longer. depending on the circumstances. Now you have cases, well, there's a lot of different scenarios with other types of cases. So you have a case that needs to be filed for one reason or another. That could be because we have a different viewpoint on liability. Maybe it's still a motor vehicle accident, but we think that there's another driver that was at fault. They don't agree. It's not a clear situation where somebody ran a red light and they were cited. This is more of there's different witnesses, and maybe there's different witness statements and different uh, testimony, statements, information is pointing to who may be responsible. So we have a position that the other driver's at fault. They disagree. That case is a case that's going to need to be filed. Or even in a case where there's clear liability, we may not come to a meeting of the minds on the value of the case. So we may think the case is worth a lot more than the defendant's insurance company, which happens, uh, which happens a lot, and we need to file the case. And it's more of an issue of damages, what the case is worth. Then you have different types of cases, say, for example, a medical malpractice case, which is more complicated. Though that case is 99% of the time going to have to be filed. So, in a scenario where a case is filed, there's a lot involved after the fact. You go into a discovery process where depositions are taken, and there's documents and information is exchanged between the parties. That's called discovery. The depositions are discovery. So, depending on the number of defendants, the number of defense lawyers, how complicated the case is, I mean, you could be in that process for a year to 2 years, just in the discovery process. I mean, I've had cases where, you might have to take 25 depositions depending on the scenario, and there's voluminous documents and things that have to be exchanged, and then you start approaching a trial. So the short answer is a case can take anywhere from 6 months to 3 to 4 years, depending on the nature of the case, the complexities, the injuries, the number of defendants.
Sounds like for the cases, there's a general outline that is followed for them, but it's not guaranteed you're going to be going through every step of that process. And every case is still going to differ because every case is unique in some degree and situation. So, for the most part, you're going to follow a pattern in order to get through those cases, but not necessarily every case is going to follow 100% and hit every step of that.
Yes and yes. Yes. Yeah, yeah, there's a general pattern that's followed, but every case is different.
Gotcha. Gotcha. Now, one thing that you mentioned during that is that, in some cases, uh, you might be able to resolve it, and we'll say, short term, 6 months. How long, and building off of another point you mentioned, which was, you want a full assessment of someone's injuries. How long do you typically wait following an accident when someone calls you before you decide to start filing and start, the work on the case while you're still evaluating their injuries? Or are you able to file right away, but you just don't take next steps until you assess their injuries further? What does that typically look like for you?
Again, that's something that's really a case by case basis, and liability plays into that. Um, if assuming liability is clear, and I we'll often be able to have a conversation with, say, the defendant's insurance company that would agree with me on that. Then maybe it's just a wait and see, and see how much treatment my client requires, and how their injuries progress.
So there's probably some degree. So it sounds like based on that, you can usually assess, at least based off of an initial phone call or whatever, that there's going to be some sort of case and there's some sort of injuries involved. So you can at least start the process fairly early because you can determine that there are injuries involved. It's just determining the extent from there, right?
Depending on the type of case. So let's take a look at a medical malpractice case. So Medical malpractice case, most of the time, I can rule a case out. That's I can make a determination that when a case isn't a case, but to know with certainty that it is a case, that I need to consult with experts, with medical experts, physicians, um, to make that determination. Number one, as much as I research and spend time reviewing medical records and medical literature, I'm not a physician, so we need the assistance of a medical doctor to determine if uh, there was malpractice, if the standards of care were not met. And two, that's required. For example, in Pennsylvania, it's a requirement. It's a law. You we need to obtain an opinion from a doctor of the same or very similar specialty as a potential defendant, um, before you can even file a medical malpractice case. So, in some types of cases, I can make the call. In other types of cases, I may need to involve an expert, even just in the decision-making process. And that could be in a products liability case. It could be, it could be in a drug case, a defective prescription drug case. It could be anything where I need expert uh, evaluation, opinions to determine if there was negligence.
Gotcha. Do you have a list of experts that you usually are able to call on? Like, do you have a directory that you go to, or do you just kind of do your research whenever you're looking for experts for a case? How does that play into it? Do you spend a lot of time researching for experts? Do you just have a guy you can hit up whenever you need something for a case? What does that look like for you?
Both. I mean, I have a list of experts that I have worked with on prior cases. I have a list of experts that have been recommended by other attorneys. There are general lists out there. There are companies out there that do nothing but provide experts for litigation, for lawsuits. So it's a combination.
So it's the full spectrum for that. A little bit of everything and everyone.
Right. I mean, if it's an area where I don't have an expert that I've worked with personally, the best thing is to, I think, reach out to other attorneys who have had similar cases and who've had that expert, worked with that type of an expert, get a recommendation.
Do you have an estimate on how likely it is that a case will actually go to trial?
Less than 10%, if not less than 5%. Most cases will settle.
Is there a point in the process that cases are most likely to settle at, or is it just anywhere in the process? Is it right when you're dealing with the insurance company? I know you kind of touch on it a little bit, and we'll get into it a little bit later. But mediation, arbitration. I mean, where in the process do you typically see then the most cases resolving?
Again, that kinda depends on the type of case, but, um, so there are cases that can settle without even filing a lawsuit, okay? You're again, you're take your clear liability motor vehicle accident cases, clear liability, a drunk driver, somebody runs a red light, somebody whatever the circumstance, it's a clear negligence case. The defendant, driver, and their insurance company are admitting liability. So then it just becomes a question of when you know what the extent of your client's injuries are, and you can try and resolve that. um, when you have a case that needs to be filed, which are a lot of them, the auto accidents, motor vehicle accident type cases can usually move along quicker than, say, a medical malpractice case or a more complicated case. So once a case is filed, then the defendant is going to be assigned a defense lawyer through their insurance company. and that lawyer is going to file an answer to the lawsuit, and then we're going to get into discovery. So at that point, that lawyer is going to want to get information uh, about the case, and we're gonna have to go through that, most likely that whole process. Like I said, that can take anywhere up to a year. So most cases that are filed, you're now looking at, could be, a year before you're probably gonna have a serious settlement discussion. And medical malpractice cases, or nursing home cases, cases of that nature, you even a little close, usually closer to trial, because a case like that requires an expert report. So both sides, but particularly the defense, are going to typically wait until that report is produced to gauge, I guess, the strength of the plaintiff's positions on liability, and the strength of our experts as part of their process in evaluating the case.
You mentioned for one part of the case, and one that can take a little bit of time, is the discovery process. And you touched a little bit on what the discovery process is. What is involved in the discovery process? What are you looking for? What is the defendant and the defendant's attorney looking for? How closely do you even work with the defendant side on the discovery process? What's all involved for this whole spectrum of discovery?
So at a minimum, my client, the plaintiff's deposition will be taken. The defendant or defendant's depositions will be taken. Okay. Now, there could be a case where there's one defendant. There could be a case where there's a half a dozen defendants. Um, and then, depending on the case and the circumstances, other depositions may be taken. So, take for example a medical malpractice case. So, let's say we file a lawsuit where we have claimed that there was malpractice during a surgery. So, let's say the surgeon and maybe the hospital are defendants. Well, I would probably also take the depositions of nurses in the OR, surgical techs in the OR. Um, Imaging may become an issue, so there's radiologist depositions that may need to be taken. Um, and anyone involved in the surgical process. If it's an emergency room case, there's people, there's the ER nurse, there's the ER doctor, there's all of the professionals surrounding the care that was provided. And then potentially there's other physicians involved in the care, someone primary care physician, or if there's issues that become involved related to, like, why the patient was referred, or what the condition of the patient was before treatment was provided or after treatment was provided. So then you have all those ancillary doctors that may need to be deposed in a case. If you have a case, let's say, against a corporation related to an accident at a factory or a construction accident, so you have the supervising employee from the company. You have the safety director who would need to be deposed. You have just people that were witnesses, workers at the accident site that need to be deposed. You may have other personnel or management within the company that need to be deposed, depending on the different issues in the case. And then on our side, of course, the plaintiff, and often the plaintiff's spouse, or if there's anybody else relevant to our case, our claims, that the other side wants to depose. In a motor vehicle accident case, you're gonna have the driver, you're gonna have the plaintiff, but there could be a number of witnesses. If it's a trucking case, again, you might have to go up the ladder. If there's an issue of procedures or protocols or training, or negligent hiring, then you may have to get into some of the personnel at the company. So those are the depositions where somebody comes in and they're asked questions by the party's lawyer, and they're under oath and they have to answer the questions. And then there's the exchange of discovery. Well, there's exchange of documents within the discovery process. So that's documents, that's photographs, that's reports, that's anything that could be potentially relevant to the case, and that's exchanged. And then often what happens is there's disagreements, arguments over what needs to be produced, what was produced, what wasn't produced, and then there's motions that are filed, and then we're in court in front of a judge arguing over this issue in discovery or that issue in discovery. So that kind of fits into all that.
Yeah. Let me ask you as well, as time has changed over your 25 years of practicing, how has social media impacted the discovery process? Has it made it easier, harder? Has it had more beneficial and negative effects because people are posting everything these days? How has that impacted the discovery process? Is it even used in the discovery process?
It definitely it has to be considered, right? Most people have some kind of social media page, right, Nick? Like a Facebook account or Instagram or something. So we always talk to our clients initially about social media. Um, they have to be aware of what they're posting, how it comes across. Things can be taken out of context. I mean, I've had cases where people have serious injuries, but if you looked at one particular post of one particular thing that they were doing, you'd think that they were happy, healthy, and everything's great. But pe- people don't post the bad things. They don't post the tough times.
Right. No one's posting themselves being miserable and, suffering through it. Yeah.
Right. So we have to take a look at that initially. And because certainly once a case is filed, the defendant and their counsel and their people are going to look at that. If somebody has a public social media page, public Facebook page, for example, um, then there's not a battle over it. It's just a matter of look of what have they posted that could be relevant to the case. If it's private, then there's different scenarios when the other side, the defense, may or may not be able to have access to it. They may be able to compel my client to um, open up their social media posts to them, depending on different factors and circumstances.
So public is basic. Well, public is public. If you put something publicly and anyone can access it and they can see it, I mean, it's basically fair game for the case.
Right, public, am I right? I mean, public, anybody can see it, right?
Right, right, right.
But a lot of people have their page private.
Or, fake accounts or second accounts and like all sorts of stuff out there. So when you get into that realm, it gets more complex.
But if there's evidence that there may be something of relevance, that the other side can show there may be something of relevance there, then they can potentially obtain access to it.
Well, I'm sure as to that point too, if there's something out there on a private page, it's beneficial for you to have access to it as well because it helps you, you know, make a claim or know what you're up against as, someone defending the plaintiff themselves. You don't want something sprung on you last minute that you had no idea was out there because someone was stupid. And I'm sure it's happened, but
Not me, but yes. I mean, well, just the people with their posting, right? I mean, I've had cases where I've had to have my paralegal sift through thousands of pages of posts to see depending on if there's like a discovery order or what's it for us to take a look at it. I mean, yeah, but it's something that needs to be considered for sure.
so I know another part of the personal injury process are staged known as mediation and arbitration. Can you provide, just to start, a definition of what mediation is and what arbitration is?
Certainly. So, mediation is a process whereby the parties get together with a mediator. A mediator is, for example, a retired judge who has a lot of litigation experience, or it could be an attorney who has a lot of litigation experience. And the parties will sit down with that person, and the mediator will guide, manage the process, and see if there can be a settlement. So it's formal, but it's informal. There's not testimony of record from mediation. Nothing from a mediation is admissible at a trial, but it can be a successful process to get a case resolved because number one, the parties are all together. There's a time period allocated to that. It could be a day long mediation. It could be a half a day where you're sitting there and you're just focused on trying to settle the case. And then you have this person who has the experience with the type of case that you're mediating, who can weigh in and tell this side this is what's good about your case and this is what's bad, and then tell the other side the same thing, and here's what I think and here's where we are, and it's a back and forth process. It's a settlement meeting run by a mediator.
During this process, uh, it's not just the attorneys, right? It's both sides. So it could be the plaintiff and the defendant present at this mediation meeting, correct? Or is it just the attorneys that are present with a judge, a mediator?
It would be the parties and their attorneys and the mediator,
Gotcha, gotcha. Okay.
because I can make recommendations, but it's ultimately my client's decision whether to settle a case or for what amount. So my client's there, the party, the plaintiff, myself, the defendants, their attorneys, and the mediator. And it just takes place. It could take place in my office or the defense lawyer's office or the mediator's office in a conference room. And the mediator will come in and talk to the parties together briefly, and then the parties kind of split up. And then it's just a back and forth. That's the defendant starts with an offer, and let's say then it goes to us, and we come back with a counter demand, and there's a back and forth, back and forth, back and forth, and maybe we get the case settled. Some counties have mandatory mediation. For example, Washington County has that in their local rules where cases should need to be mediated. Some counties push for it. When I say, I mean the judges will push for it. Some don't. Sometimes one side or the other. Oftentimes, the defendant's attorney, defense counsel will just reach out and say, "Hey, you want to mediate this case?" Or I may say, "Hey, maybe we should mediate this case." And if there's an agreement, then we sit down and try and get it resolved. As you asked about arbitration, so there's different types of arbitration. So there's contractual arbitration. Um, Oftentimes when you sign something, it could just be like a set like an invoice, like a sales slip, right? Like when you're purchasing something, maybe let's say when you're renting a car, you have to sign, or your services that you're buying for your house, you're signing something. There could be language in there that says if you have a problem, if you have a dispute, that any such matter must go to arbitration. So it's a it's a mechanism where the potential defendant, in those cases a company, wants to avoid a jury trial and wants to have the case decided by arbitrators as opposed to a jury. So there's contractual arbitration. And then with those types of cases, again, depending on the facts and the law and the circumstances, maybe or maybe not, they're able to do that. So there's scenarios where even though there's arbitration language and something that you sign, doesn't necessarily mean that they get to go to arbitration. Like, so as an example, I had a case not that long ago against the trampoline park. And when you walk into those facilities, a place like that, um, in this case, it was an electronic signature. I think it was on a computer screen, and you just X the boxes, or you had a little one of those little like electronic pens you signed. There's all kind of language in there.
Right, right. It's the classic, you sign the agreement, no one actually reads through it or checks it. You just sign off as quick as possible and get get the
Right. If you read if you were to read that language and that language would all be upheld, you're giving away a lot of rights. Okay. If something happens at the trampoline park. But so in my case, the injured party was a minor. Um, I mean, there's a whole big backstory to it. But one of the issues was in Pennsylvania. Um, well, a minor can't enter into a contract like that, okay? Their parent would have to. So in this case, mom signs that, but the law in Pennsylvania is a parent cannot waive a child's, right to a jury trial in a personal injury action. So even though there was language in there that would be forced arbitration, it wasn't upheld, and we were able to take the case in a different direction towards a jury trial. Which is what we wanted to do. So, there's often issues with that kind of an arbitration. There's arbitration based on the value of the case. If you have a case that, depending on the county, it could be anywhere from, say, 25 to $50,000. If it's if you're valuing it less than that, when you file your complaint, it goes into arbitration. So what that means is the case is decided by a panel of arbitrators, 3 attorneys from that county, as opposed to a jury or even a judge.
how are those three how are those three attorneys chosen? Just real quick and chime in while we're on the point. Is it random? Just is it somewhat similar to the jury selection process? Yeah, how are those attorneys chosen for that panel?
They volunteer.
Okay, okay.
I've been an arbitrator. It's been a long time, but in Allegheny County, you just put your name on the list that you're willing to be an arbitrator, and then you're periodically called and you serve as an arbitrator, and you hear the case, and you and the other 2 lawyers make a decision. So smaller value cases uh, would go initially into that arbitration process. Um, and then the other type of an arbitration is more similar to like the mediation that I was explaining to you, but it's it's a binding process. So the same people that act as mediators to try and settle a case can also act as a arbitrator, and so 2 sides can agree, instead of going through let's say a 2-week jury trial, okay, they could agree to a binding arbitration where, again, a retired judge or an experienced lawyer will hear the case, hear the evidence, hear both sides' arguments, and make a decision, which could take a day or 2 versus a week or 2 weeks. So that's the other type of arbitration.
Are they common in the process? Do you usually get to a point where you'll need mediation and arbitration? And do you go through mediation before you go through arbitration, or can it be a one or the other type situation? Can you go through both? How does that play into the process?
Mediation is pretty common. More I'd say more of my cases have gone through mediation than haven't. Um, that the binding arbitration is not very common. But if I understand your question, do you go through arbitration first? No.
Yeah, I'm not sure if there's a set method where it's like you have to go through, or you'll go through mediation before going through arbitration. Or
Well, it yeah, I mean, again, and these are kinda rare, but Like, if you're stuck in the contractual arbitration, you're stuck. Like, one area where this arises is in nursing home cases. And again, this is something, so there's a lot of legal issues involved because oftentimes people are signing things that they don't are even aware that they're signing. But a lot of nursing homes, when you're signing someone in, okay, a parent, let's say, as an example, there might be language buried somewhere in there where you're agreeing to arbitration. So that if it turns out that there's negligence at the nursing home, okay, and there's damages, injuries, and you file your lawsuit, the nursing home will turn around and say, "Well, you agreed to arbitration." So if that would hold up, then you are bound. You're stuck in arbitration with an arbitrator or arbitrators deciding the case.
After this process, we've gone through the phone call, we've tried to settle, hasn't worked. We've tried mediation, hasn't worked. For some reason, case as well, it's also gone through arbitration, hasn't worked. We're approaching the point where it looks like we're going to be having a trial. What does that look like? What's the preparation involved?
So every county is a little different procedurally as far as how the trials come up and when they come up. But in every county, the client is going to have significant notice. It's not going to be, well, we got a trial tomorrow. Okay, so like let's take Allegheny County for example. It comes up as you get on a trial list. I mean, you're looking at, you got 6 to 8 months notice of when something's coming up for trial.
I also assume at this point too, you probably have an idea if something's going to trial because you've been with someone through the entire process. I assume if you haven't resolved it and you're not reaching a resolution at some point, that it's far more likely, and you're probably having a conversation with your client that a trial is a possibility of something that you're going to be going through.
Every case I file, I proceed as if it's going to trial. I mean, even though very small percentage of them go to trial. I mean, that's the way I operate because that's what I have to do. So I have to do everything that needs to be done as far as obtaining information and all the depositions and research and everything that needs to be done along the way. But um, so, as far as the client's concerned, they're going to know. And again, just because there's a trial date doesn't mean the case is going to go to trial. More cases that are filed settle close to trial than at any other time. So a lot of cases settle a month, a week, 2 weeks, a couple days before trial, unfortunately, because that's hard. That's hard on the client. And and that's a lot of added expense because if there's experts involved and a lot of those people have to be paid. So, but depending on the case, the client should, I'll be able to. Well, we need as part of our filings, we have to let the court know how long the case is gonna take. So, usually there's not a big disagreement on that. So, if it's gonna take 5 days, defense and plaintiff agrees, then it's gonna be 5 days. So, the client knows how long to expect. Um, I mean, there's a lot that's going on behind the scenes that we are doing, counsel for the client. There's a tremendous amount of preparation involved for a lot of trials. Preparing for, our witnesses, preparing to question our witnesses, preparing to cross-examine the defendant's witnesses and the defendant's experts, and trial exhibits. And depending on the type of case, if we need to bring in like somebody from your company, right, to bring in to help us with um, presentation and that type of thing. So there's a lot involved on our end preparing. Um, And of course, part of that is preparing my client, the plaintiff, to testify. Um, and it can be a very trying. It's always a trying process for a client, for a plaintiff, but depending on the circumstances, it can be, really, it can be really difficult, right? I mean, think about a case where it's a death case and somebody's husband or wife or child, or and everything that's involved there, sitting through that for a week. And there's a lot of emotions, a lot of emotional things there, and can be a lot of frustration. And so it's trying to prepare a client to go through that process. And um, if that answers your question.
Yeah, it's just a lot of prep work, and I'm sure how you approach and handle cases are, I mean, different per. I mean, is there any piece of advice that you give any clients going into it that you try to give universally, that you're like, you know, this is what you should expect, this is what you should prepare for going into a case. Um, you know, uh, it's a lot for the processes from what it sounds like, but I'm sure you're dealing with also a lot of people that they've never needed an attorney before. They've never had to think about going to trial until they've been put in this situation. So, it's a new experience for a lot of people.
It certainly is. Yeah, it's a very new experience for people. I mean, I will spend a lot of time with a client as far as how to handle themselves in a trial. I mean, the jury is there. I mean, other than being excused for a few arguments or discussions, 95% of the time. So, you know, a jury's paying attention to not only what you say, but how you look, verbal and non-verbal things. So, the client needs to be aware of that, sitting in a trial. It's part of like anything else, it's part of how they're being evaluated by the jury. I'm being evaluated by the jury. They're being evaluated by the jury. The defendant's being evaluated by the jury. The defense lawyer's being evaluated by the jury. So there's a lot of things that go into that the client needs to always be aware that they're being looked at, whether or not they're on the stand.
So, since we've wrapped up talking about trials, I wanted to ask about the outcome of the trial, the verdict that a jury can reach specifically. Verdicts can be awarded for either party, and there can be instances where a jury has to determine the fault and negligence of each party in a case before awarding a verdict, correct?
Yes, there are a number of different circumstances where the jury may be asked to apportion fault. So you have a case where we sue a defendant for whatever reason, and the defendant makes a claim that my client is also negligent. Okay, contributorily negligent. So a good example for that would be like a premise liability is the technical term, but a fall down case. You're somewhere and there's something wrong with the walkway, the stairs, the lighting that's too dark. It's whatever the situation is, and somebody falls and they get hurt. You're almost always going to have, in that kind of case, the defense saying, well, I mean, they're not going to admit necessarily that they were negligent, but they're going to make a claim that the plaintiff was negligent, wasn't paying attention, wasn't watching where they were going, walking too fast, walking too slow, whatever their claim is. So, in in a case like that, the jury would be asked a question: was the defendant, okay, negligent? Basically, little different question, but was the defendant negligent? And then a few questions later, the question they would also be asked to answer is, was the plaintiff negligent? And then if they find that the plaintiff was also negligent, then they have to assign percentages. Percentage out of 100%, who was what percentage the defendant was negligent and what percentage the plaintiff was negligent. If it's less than 50% on the part of the plaintiff, then the amount of the verdict gets reduced by that percentage. So let's say that the jury comes back and says, yes, defendant um, trampoline park was negligent and that was the cause of the plaintiff's injuries. But then the jury also finds, well, the plaintiff was also kind of careless. So if the jury finds that the defendant was 80% responsible, the plaintiff was 20% responsible, and awards $1 million, that $1 million gets reduced by the 20%. If the jury would come back and say both parties were negligent, okay, but the plaintiff was more than 50%, say the plaintiff was 60-70% negligent and the defendant was 40-30%, then there's no recovery.
How often does this actually happen in a case or trial? I assume for some cases like medical malpractice, it's very unlikely or uncommon that there will be any debate that the plaintiff could be at fault. But in cases such as auto accidents or premise liability cases, it's probably more common.
Probably most common in like a, yeah, premise case, property fall down type case. It's almost always an issue, yes. Sometimes in motor vehicle. Mhm. So not that uncommon, in very common in any kind of a premises case. Sometimes in a motor vehicle accident, but almost never in a medical malpractice type case, you're correct. Where there's any reasonable argument to be made that the plaintiff was negligent.
So, taking a step back from the trial and verdict side of things, what actually happens when someone decides that they want to settle their case?
When there's an agreed upon amount, both sides have agreed, we get paid. We get paid, baby. Finally, my clients get some money, right? And I get paid. That's that's usually a good day. Right. Um, yeah, once if we're able to get to that point, once we get to that point, there's not much, else that it would occur. So we agree on an amount. The defense, sends me a settlement agreement, which basically would say which my client would be asked to sign, and it's to summarize, in consideration for 200, say $250,000, my client is waiving, relinquishing, giving up all rights to any claims against the defendants, whomever settling, um, and that's provided by the defendant to me. I review it, assuming it's okay, there's no issues, my client would sign that, send it back to the other side, and then the case is settled, and, just wait for a settlement check. Um, and for that, you know, usually few weeks, 20 days we should have a check for the client. If the case is filed, then it gets discontinued by us. We file something very basic, something discontinuing the case, and then it's over.
Now, that sounds it's a win-win. It's a good case scenario for everyone. Now, on the other side of things with that, you settle a case, but your client then comes to you and they realize 2 months down the line their injuries were worse or something else is related to it. Once you've settled, that's it, right? You're done. There's not speaking in absolutes, but there's very little, and it's very unlikely that there's going to be any way to reopen a case or have anything involved with that once you've settled, even if injuries are discovered to be worse later on. Correct.
Yep, you're SOL there.
So there's nothing anyone can do as to that point. Just it's been settled.
No, I mean, it would have to be in the rarest of rarest situations, but no. I mean, the release is gonna say if you'd have to look at a release, I mean, it's gonna cover all that. All injuries, potential injuries, all damages, injuries seen, unforeseen, anything that possibly arises out of this accident, out of this occurrence, you are releasing. You are settling for X number of dollars. So that's but that, that's my job, like we talked about before, to make sure that I have an understanding, along, with my client, and they're giving me all the information. I'm reviewing all the medical records, you know, to make sure I have an understanding of all of the injuries, potential damages, and that's all factored in, and that they clearly understand that, this is it once you settle the case.
All right. Thank you for that. Now, there's one last question I have before we wrap things up. How long does someone have to file a claim? I know the known term for this is the statute of limitations. Is there a time frame people should be aware of when it comes to filing for their personal injury case?
2 years is the statute of limitations, meaning that you have 2 years from the date of the accident to file your lawsuit in almost all personal injury situations. Auto accident, medical malpractice, premise liability in Pennsylvania. Now that varies from state to state. For example, I'm licensed in Florida, and I've done work in Florida. Their statute of limitations is 4 years on a lot of those claims. Pennsylvania is 2 years. I had a case not that long ago in South Carolina. It was 3 years. But in Pennsylvania, it's 2 years.
Any instance, situation where the 2 years does not apply to an individual for a personal injury case?
Two of the most common situations would be a minor's case. So a minor has 2 years from when they turn 18. So you're 10 years old, okay, and you're injured by somebody's negligence. You have 10 years to file a lawsuit, okay? Mo Now your parents may have claims that you need to file to preserve, but the crux of the case, the minor's case, a minor has until they're 18 plus 2 years to file a lawsuit. The other scenario where it can be an exception, to this is, and you see this, not infrequently in, say, medical malpractice cases, what's something that's called the discovery rule. So you receive treatment, you have a procedure, you're under the care of a physician, and some point after that, right, you start to have health issues. You're not really sure exactly what the condition is, what you're suffering from, what's causing these problems, okay? And you're maybe then you follow up with some other doctors and they're not sure. But the bottom line is, if you don't discover the what you're claiming to be the negligence, okay, for over 2 years, then that can toll the statute of limitations, okay? And obviously, it doesn't come into play like when a clear accident case, you have a motor vehicle accident, and you break your leg, it's a motor vehicle, car crash caused your broken leg. But in other situations, it can be more complicated, and a client may not realize the cause of their injuries or problems, or even realize the extent of their injuries for a long period of time. And that can toll the 2 year period to file a lawsuit.
Gotcha. No, that sounds good, and I think that's an important point to make when we're talking about the process. And if someone's getting ready to call you up, is don't wait too long. I think the 2 years can come and go a lot quicker than people realize. And if they think that there's any risk of injury or having anything prolonged, or they've been in an accident or any sort of situation, they should make the move and get a hold of an attorney as soon as possible to at least talk about their situation, and take it from there. So they're not waiting. They don't risk, running out that statute of limitations.
That's a very good point, and that's what you're 100% correct. So, if I have a case that needs to be filed, I mean, I don't like to, let's say there's a 2-year statute of limitations. At the maximum, I don't like to wait longer than a year, okay, to get it filed, because what can happen is you can learn things in discovery, okay, where maybe there's other defendants. There's another party that was involved that we weren't aware, we couldn't have been aware of until you get in discovery and you start taking depositions or get information. Or what can happen is, like a lot of these corporate, a lot of these companies, they have. So, for example, I had a case recently against a local coal company, okay? And so, they must, they probably have a dozen different corporate entities. So there was an accident in a mine, uh, so we had to sue the entity within that coal company, okay, that was controlling that particular mine. Well, because I filed early enough, we realized it was, instead of Pennsylvania Coal, this one else, or this, Energy LLC. We had to amend the complaint to get the proper corporate entity within that company into this case. So you need you don't want to wait till the last minute.
I think that's great advice for anyone watching or listening. That should wrap it up. And if anyone has any questions, you can reach Dave at zimmerolaw.com. That's ZIMMAROLAW.com. Or you can reach him by calling him at 724-222-1221 for his Washington office, or 412-391-6670 for the Pittsburgh office. Thank you for your time, Dave.
Thank you, Nick. Thanks.